All right, well, I'll go ahead and call us to order here. So my name is Mark Allen Smith. I'm an Associate Chair of Political Science at UW, and I'd like to welcome you all to our third in a three-part lecture series on the election 2020. So in our previous sessions, which many of you have been to, we've covered climate change and how it's intersecting with the election, how the election will play out in terms of U.S.-China relations. We've done polls in the Electoral College. We've done election security and election integrity. And then tonight, we have the good fortune to have two professors from our department. And we've designed really the whole series around topics that we could speak to authoritatively with faculty members who have expertise in that particular area. So I'm pleased to welcome you all tonight. And our two speakers are going to be Professor Rebecca Thorpe and Professor Scott Lemieux. I'm going to start off here introducing Professor Thorpe, and then right before Professor Lemieux's talk, I will introduce him. So the plan here is each speaker will go for about 15 minutes, and then we'll have time for questions and answers at the end. So as we're going along, feel free to jump in at that point. Use the question and answer button. Most likely located at the bottom of your screen, and just go ahead and type in there any question you'd like for either or both of our panelists, and I'll be fielding those questions as the moderator. I probably won't be able to get to all the questions, but I'll get to as many as I can, and if there are like two or three that are kind of on a related area, then I might combine them and try to make the most of our time. So let me begin by expressing my pleasure for introducing my colleague, Professor Rebecca Thorpe. She's an associate professor of political science, and her research and teaching areas are in American political institutions, and she writes especially on state development and in the areas of the prison industrial complex, suburbanization and urban gentrification, and military spending. She has won several awards, including two from the American Political Science Association, which are quite prestigious honors, and another one from the Lyndon B. Johnson Foundation. And here at UW, she's a very popular instructor, and she teaches courses on American politics, the presidency, and American political institutions. So it's my pleasure to bring you Professor Rebecca Thorpe.
Thanks for that introduction, Mark. And thanks to everyone for being here and logging in. I know it's been a very, very long campaign season. There's a lot of anxiety about the upcoming election. I'm going to discuss executive power and what to expect in 2021. And I'm going to begin with something that I do not typically do. I'm going to make a prediction. And my forecast is that executive power will expand after the 2020 election. And to be clear, I expect that this will happen regardless of which candidate takes office and no matter which party wins the House and Senate. Now, the key qualifier to this claim is that these election outcomes do matter tremendously when we consider both the extent and magnitude of executive consolidation and the consequences for our democratic institutions. So my talk will unfold in two parts. First, I'm going to discuss the historical basis for expansive executive power. So specifically where we should expect to see either a Trump or a Biden presidency push the bounds of their authority to promote their policies. And secondly, I'm going to discuss what's historically unprecedented in our current context. And here I'm going to highlight some of the consequences for democratic norms, values, and institutions. So to begin, I want to take everybody all the way back to the Obama administration, which sometimes feels like a lifetime ago. This is an image of presidential success rates in the US House from 1953 to 2009. And as you can see here, Obama's success rate in the House was really high when he took office in 2009, over 90%. And this is when he had strong Democratic majorities. But in 2010, Democrats experienced the largest midterm loss since 1938. They lost 63 seats in the House and 6 in the Senate. And subsequently, Obama's success rate in Congress plummeted to about 21% in 2013. This also coincided with what's now known as the least productive and perhaps most obstructionist Congress in our history, including a national shutdown, a debt ceiling crisis where the government nearly defaulted on the national debt. All the while, Congress refused to vote on proposed legislation and fill judicial vacancies. And this includes not only the Supreme Court vacancy in Obama's nomination of Merrick Garland, but also hundreds of federal and appellate court judges whose seats remain vacant. And by this metric, it looks like Barack Obama is perhaps one of the weakest presidents in modern history. But success in Congress and key legislation is only one metric of presidential success. Now, given these levels of congressional obstructionism, Obama used tools like executive orders to promote his policy goals. So an executive order is an independent directive to the executive branch. It's distinct from legislation that goes through Congress, but these orders do have the effect of law. So the Obama administration unilaterally pursued a number of policy goals, including expanding environmental protections, implementing DACA, which was a policy that shielded immigrants brought to the country as children from arrest and deportation, increasing oversight of gun purchases, easing terms on student loans, implementing transgender right protections for federal employees, expanding domestic spying, increasing military strikes overseas, overseeing military drawdown in Afghanistan, and going to war in Libya. Now, these independent executive policy tools are not new. They've been used particularly aggressively since World War II, and they allow modern presidents to do two things. They allow them to move first, and they allow them to act alone. So, as I mentioned at the beginning of the talk, we should expect to see more frequent and more significant unilateral executive action. And I'm going to provide some historical context to help explain why this is. Now, Franklin Roosevelt issued executive orders more frequently than any other president, and he did this despite strong congressional majorities. He issued over 3,700 executive orders in his 12 plus years in office, which averages to, I believe, about 307 executive orders per year and almost one per day. Historically, presidents use executive orders more, not less frequently, when their party controls Congress. And finally, presidents have increasingly invoked new unilateral policy tools. This is particularly the case since the Reagan administration. So, for example, the number of executive orders has declined in the Obama administration, but as president, Obama aggressively issued a policy tool called a memoranda, which is similar to an executive order, but it's less well known and therefore more discreet. And presidents have a slate of different tools at their disposal, including proclamations, signing statements, executive agreements, and national security directives, none of which need to go through Congress. Now, in Trump's first 100 days, he also enjoyed strong Republican majorities. He had campaigned on what he called executive overreach in the Obama administration. Yet he issued more executive orders than any president since Reagan. Now, just looking at the raw count of executive orders can be misleading because they're often administrative or symbolic. They do things like set up a task force or a commission to review a policy, but there are three specific issue areas where executive orders had a major substantive impact in the last 4 years. And the first area is immigration. So foremost, the arrest and detention of undocumented immigrants without a criminal record has more than doubled. The administration also unilaterally implemented a policy separating migrant families at the border and detaining children in facilities like repurposed Walmarts. Now, despite court orders to reunify parents and children, we've recently learned that the parents of more than 500 children still cannot be found. Many of the parents have been deported, and many of the children have been put up in foster care or for adoption. And finally, it was an executive order that ultimately banned travelers from 5 Muslim majority countries, plus North Korea and Venezuela. Now, the second issue area that I want to flag is healthcare. Now, Congress did take a series of votes to repeal the Affordable Care Act, but was unable to do so, did not have the majorities. And this was despite having Republican majorities in both chambers. So the administration went ahead and weakened the law unilaterally. And the president did this by making changes to the rules, by doing things like eliminating the tax penalty, removing certain requirements, requirements for things like maternity leave and mental health, and ending subsidies for low-income households. And of course, the fate of the Affordable Care Act is currently pending in the US Supreme Court. And finally, since July of 2018, the administration has had unilaterally reversed 76 environmental rules, including limits on carbon emission, pollution controls, and measures protecting wildlife. So as we've seen, there have been more frequent and more significant unilateral actions in the previous two presidential administrations. So the key question is, well, why should we expect this trend to continue? And I think one key reason is that the expectations of the office have changed. Our most successful presidents, those that we tend to idolize as national legacies, have all dramatically expanded the powers of the office. So this is an image of Lincoln signing the Emancipation Proclamation. Of course, Lincoln famously fought the Civil War, freed the slaves, and upheld the Union. In doing so, he also suspended habeas corpus, which is a constitutional right to be charged with a crime before being imprisoned. He declared martial law. Franklin Roosevelt's New Deal redistributed wealth, regulated businesses, and established a social safety net. Roosevelt also broke historical precedent and served more than 3 terms consecutively. And he also instituted a number of emergency war measures, one of which resulted in the incarceration of Japanese citizens without trial or due process. And finally, Reagan used the power of the office to do things like increase the military, dismantle the bureaucracy, and fight the Cold War. Now, the upshot here is that modern presidents are expected to perform a number of almost magical feats. They're expected to prevent a foreign attack, stabilize the economy, respond to natural disasters, and unite the country, among a range of other things. And their legacy depends on these things. Presidents are blamed for their inaction, and they're rewarded for economic, military, and domestic successes. So all of these things incentivize presidents to be more proactive. Now, historically, presidents' use of their executive powers have varied depending on 2 things, both their political context and their individual temperament. Now, on this latter count, Biden appears to be more temperamentally restrained. There's actually an article in the New Yorker just last week by Bill McKibbins, and he reflects on this, and he says, and I'm quoting, "There's really nothing in Joe Biden's character or his record to suggest that he would be anything more than a sound, regular, capable president." And the author goes on to comment that, far from a mundane or prosaic outcome, this could actually be a great relief. But at the same time, we're also in a period that's characterized by multiple compounding crises. We have a COVID pandemic and an unraveling public health crisis, which has exposed a woefully inadequate healthcare system. We have increasing unemployment and an unfolding economic crisis. We're faced with the effects of climate change, persistent racial violence, and voter suppression. So our political context is really ripe for bold and perhaps unilateral action. And there are really large and powerful constituencies that are demanding this type of action. So we might see a President Biden do things like embrace a Green New Deal, expand the Affordable Care Act, implement a path to citizenship for undocumented immigrants, or pursue reparations for Black and Indigenous communities. Now, from a Trump administration, I don't think that we'll see any surprises, at least in terms of policy. I would expect to see more of the same. So the arrest and detention of immigrants, attempts to close the borders, the repeal of the Affordable Care Act, a rollback of environmental regulations, tax cuts for the wealthy, and efforts to stack courts with conservative jurists. So this really begs the question, if presidential power is more or less a given, then what is at stake in this election? Now, I think something even more important and more significant, and that's democratic norms, values, and institutions. So what do I mean by that? Well, to the extent that we have a historical precedent for our current moment, I think the clearest case is Richard Nixon. Nixon used the power of the office not only to promote his policy goals, but also to target his political enemies and to evade legal liability. Now, presidents don't openly come out and tell the public that they're going to disobey the law. They tend to rely on semantic maneuvers and redefine or reinterpret what the law means. So in a famous interview with the journalist David Frost, Nixon justified his actions by saying that when the president does it, that means that it is not illegal, which is really another way of saying that the president is the law or that the president embodies the law. And this is something that is only true in the most authoritarian political context. Now, Nixon claimed the inherent power to interpret the law, and he also acted on these claims by doing things like tapping phones without a warrant, conducting secret wars, expanding the secrecy system, shielding information from investigations and subpoenas. He kept an enemies list, which included student protesters, Democrats, intellectuals, and members of the media. He ordered FBI surveillance on his perceived political enemies and put undercover agents in universities. He's perhaps most well-known or most notorious perhaps for the Watergate scandal. This was a break-in at the Democratic National Convention by Nixon's aides in an attempt to cover it up. So this included hush money to the aides that were involved, and the administration advanced a national security rationale to stop an FBI investigation. So what does this mean for our current context? Well, Trump's tenure is characterized, I think, primarily by what I would call a series of norm violations. Now, these are not things that are explicitly illegal, but they're things that violate accepted practices. And these practices, it turns out, contribute to functioning and legitimacy of our institutions. And we've seen these norm violations beginning on day one. So the president refused to disclose his tax returns or divest from his businesses. He put his family in the White House. He used the powers of the office to pardon his friends and malign his political enemies. And he's glorified violence and coercion over reason and persuasion. So this image on the screen is a doctored video that Trump tweeted in 2017 of himself wrestling a CNN icon. So this is an image of the president sort of violently attacking and even pummeling the media, which he's characterized as a political enemy. The administration is also characterized, in addition to norm violations, by efforts to evade legal accountability. So for example, the president claimed unlimited power to supervise the Department of Justice, including firing the head of an FBI investigation that was targeting him, ordering an investigation of his political opponents, defying subpoenas, prohibiting aides from testifying, and his legal team has even claimed that the president has the right to pardon himself of any crime. Now, his legal basis, the president claimed that Article 2 gives him, quote, the right to do whatever I want, which is perhaps a more candid formulation of Nixon's infamous claim. And finally, and most recently, the president has signaled that he may not accept the election results. He sought to undermine confidence in the election outcome, and particularly the legitimacy of mail-in ballots. This headline is taken from an article in The Atlantic that went viral just a couple weeks ago. And the article outlines how the president's legal team is laying the groundwork to circumvent the vote count in key battleground states. So I think the upshot is twofold. First, I think that expansive executive power is more or less a given, particularly in a crisis. Presidents will use their unilateral policy tools to pursue their goals. But the election also has very serious consequences for our political norms and institutions, including mechanisms of legal accountability, fidelity to the rule of law, and democratic governance. So thank you so much. I look forward to all of your questions during the Q&A.
Excellent. Thank you, Professor Thorpe. And I'll remind you all that if you have a question for her, go ahead and drop it into the Q&A chat box on the bottom of your screen. And the same thing, if you have questions for Professor Lemieux coming up. So he is an assistant teaching professor at the University of Washington. He specializes in judicial politics and constitutional law for both his teaching and his research. He is the co-author of an excellent book from 2017, Judicial Review and Contemporary Democratic Theory. And he also writes widely for many outlets that you've heard of, such as the LA Times, The Week, The Guardian, Real Clear Politics, amongst others. And if you want a smart and witty take on political developments, I would direct you toward his Twitter feed. And at UW, he's a popular instructor and with high student enrollment and demand for courses such as American politics, the presidency, constitutional law, civil liberties, and the Supreme Court. So it is now my pleasure to bring you Professor Scott Lemieux.
Scott, if you want to share your screen, please. And you're on mute, please.
Okay, so now let me, if I start the slideshow, it should, sorry, the inevitable Zoom. Is that good?
We need you to share first.
Oh, okay. Oh, I got it. All right. We're good?
Good.
All right. So like Professor Thorpe, I thought, and I'm happy to answer questions about specific cases or whatever after in the Q&A, but I wanted to sort of, stake out some scenarios and provide a little bit of historical perspective in terms of what could be a fairly unstable and difficult time for the relationship between the federal courts and the other branches. And essentially, we have, that there are a couple of scenarios that can map out, but we're really at something of an inflection point where the norms that have governed Supreme Court confirmations for most of American history are essentially dead. And it's hard to know what new equilibrium will arise from them. And the real key thing here is that while it's been extremely common throughout American history for there to be ideological factions on the court, this is the first time in which the ideological factions map perfectly onto partisan affiliation. So that, for example, if you were to look at the heart of the Warren Court was two Eisenhower appointees, Earl Warren and William Brennan, and if we were to look at the court in the 90s, two of its most liberal members, John Paul Stevens and David Souter, were Republican nominees, whereas for the first half of the decade, pretty consistent member of the conservative wing of the court was Byron White, who was nominated by JFK. So because our party coalitions used to be relatively loose and producing a certain unpredictability in the ideological direction of Supreme Court nominations, the stakes of every individual Supreme Court nomination was a little lower. What's essentially happened is that we're in a situation now where party elites are substantially more polarized than the party's ordinary voters, and this means that essentially a Supreme Court nomination is going to be a very reliable member of Team Republican or Team Democrat. Now, there are always individual exceptions, and we saw that last term with Trump's nominee Neil Gorsuch joining the court's four liberals on important cases about civil rights and the rights of indigenous people. But for the most part, the votes of judicial nominees can be predicted pretty accurately. And so partly because of these high stakes, we had something unprecedented happen starting in 2015, which is the Republican majority in the Senate simply refusing to confirm any of Barack Obama's appellate court nominations, culminating, of course, in the refusal of the Senate to even give a hearing to Merrick Garland, who was nominated to replace the vacancy created by the death of Antonin Scalia. And so for this reason, there was a pattern of the court that is now gone, and which means that the Senate no longer defers to the nominations of presidents, even presidents of another party. And you can see here, these are sort of political science estimations of the ideological positions of judges, and the yellow line running through that is the median vote of the court. And what you can see is that starting with the end of the Warren Court and its quick takeover by Republicans in 1970 during the during Nixon administration, sorry, an interesting historical event in itself. You'll see that yellow line has sort of been a moderate conservative, going from Lewis Powell to Sandra Day O'Connor to Anthony Kennedy up until his resignation in 2018 when it became John Roberts until earlier this week. And so essentially, although the court has gotten a little bit more conservative, the median vote of the court is what you might call a kind of country club conservative, so that the output of the court has generally been conservative, but with enough liberal victories that for the most part, Democrats can live with it. And indeed, this equilibrium has actually been very politically beneficial for the Republican Party in that the Supreme Court produces many more conservative outcomes than liberal outcomes, and yet Democrats actually liked the court more and were less mobilized by it. So the Supreme Court vacancy may be one of the critical reasons that Donald Trump won in 2016. That seems to be ending, but that it's sort of ending with Republicans taking over a 6-3 majority. But if you look at those lines up top, you see Chief Justice Roberts, you see Alito, and so on, is that basically the median vote of the court now is one of those justices at top. Chief Justice Roberts is moderated a little bit, but he's no longer the median vote. And indeed, it's hard to know exactly who the median vote is. Brett Kavanaugh, Neil Gorsuch, it's hard. They're essentially all very similar. So that is, a fairly radical shift of the court to the right, which, presents some interesting questions. But of course, what will happen will, to some degree, depend on what happens with the election. So if Donald Trump wins, which, you can pick your forecasting site, seems to be, somewhere between a little less or a little more than a 1 in 10 chance, then, we're simply going to be in a situation which prevailed for much of American history, where the Supreme Court is essentially a partner of the governing coalition. That, we can expect the court to more or less, issue opinions that are consistent with what the Trump administration wants. And with Chief Justice Roberts no longer being the median vote, even the sort of very modest pushback he got in cases with respect to the census and with his tax returns, we're not even going to see that anymore. So, essentially the court will not be a meaningful check on the Trump administration at all. And that's true of both the Supreme Court and the federal appellate courts, which are now dominated by Republicans. If Joe Biden wins, but Republicans maintain the Senate, and that's, they seem to have something like a 1 in 4 chance of doing that, then you're going to be in a situation where there's going to be a lot of clashes between the Biden administration and the courts. Professor Thorpe, talked about a lot of what modern presidents try to do in terms of the administrative state, and the Roberts Court with a 6-3 majority is likely to rule a lot of that unconstitutional. So if Republicans take over the Senate, essentially, Democrats won't be able to legislate, and the court is likely to push back against a lot of the Trump administration's or the Biden administration's executive actions as well. And as long as Republicans hold the Senate, there's really not much Democrats can do about that. So that would be a scenario in which the court is extremely powerful, but is exercising power against the incumbent administration rather than alongside it. Where things start to get really interesting is if Biden wins with a Democratic Senate, and particularly if that Democratic Senate has something like 52 or 53 members. And again, that is the most likely outcome right now. And that presents a real potential for a constitutional crisis. And I thought that it might be useful to think about some comparable historical scenarios throughout history to show how things may play out and the sort of choices that face both Democrats in a scenario in which they take over the government and the Supreme Court if it's facing a unified Democratic government. So I would say that the most comparable historical antecedent to the last minute confirmation of Judge Barrett to the Supreme Court would be what happened in 1801. After the heavily contested 1800 election, John Adams, finally loses, but on his way out, the lame duck Federalist Congress creates a whole bunch of new judgeships, including multiple new circuit courts, and John Adams nominates a new Chief Justice of the Supreme Court, his Secretary of State, John Marshall, who is confirmed by the Senate. In addition to that, the Federalists reduced the number of seats in the Supreme Court from 6 to 5, making it less likely that there would be a vacancy for the new president, Thomas Jefferson, to fill. So essentially, the Federalists tried to consolidate their power in the federal judiciary, having lost control of the presidency and Congress. However, this was not terribly successful. The court faced a huge blowback from the Jefferson administration. One thing that I think a lot of people don't understand is that the Constitution provides a lot of tools for Congress to retaliate against the court if it chooses to do so. Article 3 does not fix the size of the Supreme Court. It does not require any other court to be established at all and does not fix their size. It allows Congress to make exceptions and regulations to the jurisdiction of the federal courts and various other things. And we saw most of these techniques used by the new Jeffersonian Congress. So the new circuit courts were just flat out abolished and those judgeships eliminated. And one thing that meant is that Supreme Court justices had to do what's known as riding circuit. So they would hear appellate cases. And obviously in the early 1800s, that is not a very pleasant thing to do. One justice nearly died when his carriage, broke through the Susquehanna River, and he almost died of hypothermia. So that was a pretty stark retaliation against the Supreme Court. The Jeffersonians restored the 6th seat and then expanded a 7th seat for Thomas Jefferson to fill in 1807. The Supreme Court, or the Congress, outright canceled the Supreme Court term of 1802. So the Supreme Court just didn't meet that whole year. And again, the Constitution empowers Congress to do that. Jefferson and Madison also famously failed to deliver judicial appointments that were made, so made by the president and confirmed by the Senate, but not delivered to the judges, and they simply refused to acknowledge those appointments, which led to the famous case of Marbury versus Madison. The Jeffersonians also impeached Justice Chase in the House, although he was not quite convicted in the Senate. Nonetheless, the Supreme Court sort of took that impeachment as sort of the equivalent of a brushback pitch in baseball. And the crucial thing here is that John Marshall, to some degree, preserved the long-term power of the court by backing off. Although he admonished the Jefferson administration in Marbury, he said that Congress did not have the power to issue an order, so he struck down a law actually giving the courts power, the first ever exercise of judicial review, but it was really a sign of weakness, more of strength. And the next week after Marbury, the court upheld the decision of Congress to repeal the new circuit courts, although certainly that's at least constitutionally questionable. So the first attempt of a minority faction to kind of preserve its rule against a new majority went very badly for the old faction. Professor Thorpe actually already mentioned some of what went on during the Civil War and Reconstruction, but again, we saw the president pushing back against a Supreme Court that was still controlled by the old Jacksonian majority when he took power. Most famously, President Lincoln simply ignored the Supreme Court's infamous Dred Scott decision of 1857. The Supreme Court said that Congress could not ban slavery in the territories, and that African Americans, even free African Americans, were not citizens. Lincoln signed legislation banning slavery in the territories and had his Secretary of State issue passports to multiple free Black Americans, essentially repudiating the Dred Scott decision, which was then overruled by not one but two constitutional amendments. As Professor Thorpe said, saying that essentially it was not tenable to have a situation in which all the laws but one went unenforced. In the ex parte Merriman case, he simply refused Chief Justice Taney's order of a writ of habeas corpus in detaining people in Maryland during the Civil War. And throughout this period, the Republican Congress, expanded or contracted and then re-expanded the courts several times to ensure favorable outcomes that would not interfere with the Civil War and Reconstruction. And the final example of this was the ex parte McArdle case, in which a McArdle filed for writ of habeas corpus under an act that Congress had passed. Congress simply withdrew the jurisdiction, and the Supreme Court went along with that. Upholding law. And ironically, those laws go back to the Marshall Court when it was trying to sort of back off the Jefferson administration. It basically said that federal courts have no jurisdiction unless affirmatively given that jurisdiction by Congress. So that's another example. And then the third salient historical example is the constitutional crisis that occurred during the New Deal. That time, a holdover Supreme Court went very aggressively at FDR's legislative agenda, as well as attacking social reform measures passed by the states. And FDR did not get a new appointment his entire first term, which was significant since on many of these issues, the court was split 5-4. And what happened after his landslide election in 1936 is that FDR proposed expanding the court to 15 people. Now, he was a little disingenuous, arguing that this was necessary because too many of the judges were over 70, as opposed to the real reason he wanted to do it, which is that he felt the court was misinterpreting the Constitution and preventing both state and federal governments from reacting to the economic depression and the extraordinary deprivation and inequality that resulted from that. But ultimately, the court packing plan failed, in part because the Senate Majority Leader died suddenly of a heart attack, undermining its support, and then ended up failing in the Senate. But having said that, some kind of court reform plan almost certainly would have passed, except that the Supreme Court turned on its head and stopped striking down New Deal legislation. This is often called the switch in time that saved nine. Historically, a lot of people just assumed that this was the court backing off directly because of the proposed court packing plan. We now know that it's a little bit more complicated than that because we know that the key swing vote on the court, a judge from Pennsylvania named Owen Roberts, had actually voted to uphold a state minimum wage law before the 1936 election. So although the decision wasn't released until after the election, he had actually already voted. So it seems that he had decided to change his mind. But having said that, the larger political pressure around the court almost certainly was part of the reason Roberts switched. And I think that the biggest reason is that the first decision striking down New Deal programs kind of gave the courts a false sense of confidence, that several of these decisions struck down programs that even a lot of supporters of FDR were no longer huge fans of and were not particularly popular. Indeed, a couple of these decisions were 9-0 or 8-1 rather than closely split decisions. But when the court most prominently struck down a New York minimum wage law in a case called Moorhead versus DePaldo, this produced an immense public backlash. Of the upwards of 500 editorials written about that case, only 10 were supportive. Which, given how conservative editorial pages often were during this era, is quite remarkable. So I think that what happened was that the pushback against the more popular and enduring parts of the New Deal era, the pensions and labor law and minimum wage and maximum hour laws and legislation like that, I think that that Roberts was kind of spooked by that backlash. He started to uphold the programs of the New Deal, and at that point, FDR quickly had enough nominations to take control of the court, and crisis was averted, and we had a 9-justice court, and that equilibrium has now been with us since 1869. So essentially, every actor involved here, should Democrats take over Congress and the White House, will have choices to make. Obviously, there's already going to be a lot of pressure on Senate Democrats to consider, some of these reform measures, alongside measures like ending the filibuster, perhaps granting statehood to the District of Columbia and offering it to Puerto Rico and the Virgin Islands or potentially other territories. But there's also the potential for expanding the courts, and not just the Supreme Court, but also potentially the federal circuit courts, which is indeed the current Democratic platform actually calls for expanding the circuit courts. And after the decision earlier this afternoon by the Eighth Circuit to order Minnesota to not count legally cast ballots 4.5 days before the election, I suspect that if that decision stands, you're going to get more and more calls. But the courts also have a choice to make too. What has happened previously in American history is that courts kind of facing constitutional hardball from the other branches have backed off to some degree. That certainly seemed to be the instincts of Chief Justice Roberts, but he is no longer the median vote. The confirmation of Amy Coney Barrett is essentially a high stakes, high reward, but also high risk gamble for the Republican Party. They had a situation in which they had a very conservative court that probably would not have generated pushback. But now we have the question, will the court strike down the Affordable Care Act? And it's hearing a case arguing that it should do that a week after the election. What happens if the court strikes down the John Lewis Voting Rights Act of 2021 or prevents the Biden administration from regulating carbon emissions? If Democrats control Congress, you may see a pretty big fight with some of the measures that have been proposed historically going forward. So I think there's a very real chance that at some point in the fairly near future, and it could be as early as 2021, the 9-justice equilibrium ends. You may finally ask if there are kind of less radical solutions that Congress could pursue. And a lot of people have suggested, for example, limiting justice to 18-year terms, ensuring that every president gets 2 nominees, so kind of lowering the stakes of each appointment. I think that those proposals are good ideas, but they probably, although not certainly, require constitutional amendments. And we're in somewhat of a difficult situation because the Supreme Court, or the Constitution, seems to allow more radical measures against the court more easily than more modest ones, which will generally require a constitutional amendment. So that's one reason why a genuine showdown between the elected branches and the courts could get very ugly. Historically, courts have not generally fared very well in these power struggles, but it remains to be seen, and particularly given that Democrats are not going to have anything like the majorities that FDR enjoyed, or that Lincoln enjoyed, or that Jefferson enjoyed. Whether Democrats will want to or will be successful at pushing back against courts that are working heavily against their agenda very much remains to be seen. All right, so I will leave it for questions and answers. But I wanted to tell you about a fantastic looking upcoming talk as part of our WISER series, the Institute for the Study of Inequality and Race. And several of my brilliant colleagues are going to be speaking. This is a real all-star panel with Christopher Parker, Sophia Wallace, Bernard Fraga, Christina Greer, and Jane Junn. I really strongly recommend attending this talk if you have the time. It looks absolutely fantastic. All right, so with that, I will turn it over to the audience. Thank you very much.
All right, thanks, Professor Lemieux. We do have some questions that have come in, and I'm sure there will be more on the way. So I'll try to kind of balance them out in terms of which of the 2 panelists we go toward. So one that came in for Professor Thorpe, you mentioned in your talk the increasing consolidation of power in the executive, especially through means like executive orders, but also related things like presidential memoranda. And you said you thought that was going to continue regardless of who won the upcoming election. That being the case, it kind of sounds like we're heading toward, authoritarian rule. And is there some kind of line that we either have crossed or will cross? And what do you make of the possibility for authoritarianism in the United States?
Yeah, thank you, Professor Smith, and to the audience for that question. I think it's a good and an important and complicated question. And I think the answer is that it ultimately depends. So if presidents use tools like, executive orders and other unilateral policy tools to promote policy goals that are favored by political majorities, that have support from majorities in Congress, in the House and Senate. I mean, I think that those are still characterized as, as democratic policies. And, we've seen that, and we've seen, independent executive policy tools since, since the Constitution was ratified, and, with increasing frequency since World War II. On the other hand, if we see presidents using unilateral policy tools to promote policies that do not have, broad public support, that systematically infringe on the rights of disadvantaged minorities, or that do things like insulate their own power or the power of their political party, shield themselves from any sort of legal accountability, increase the level of secrecy in the government and in the executive branch, reduce transparency. Those sorts of things I see as tipping points, and sort of more toward the precipice of an authoritarian outcome.
Great, thanks for that answer. I'm going to throw the next one to Professor Lemieux. So we've had a lot of norm violations in recent years, and even the last 10 or 20 years. Some of this Professor Thorpe actually spoke about in her talk. So we've had things like, a lot of American politics traditionally had norms that weren't written down. That's why we call it a norm. So things like using the Senate filibuster. It used to be you didn't filibuster anything except a really important piece of legislation, but increasingly it's just anything the minority party doesn't like, they filibuster. It's always possible that you could use the debt ceiling to force a crisis in the federal government, but it just wasn't done until the Republicans discovered during the Obama administration that there's nothing preventing them from doing that. So they could if they wanted to, and they decided they did. So that was a norm change or violation. And Professor Thorpe mentioned things like President Trump not releasing his tax returns, using the office to enrich himself through his hotels and other business enterprises, as well as his children. A lot of that might well be legal, but certainly a norm violation. There's no law that says presidential candidates have to release their taxes. So then we get to the matter of, quote, packing the Supreme Court. And as you said, that's a perfectly constitutional thing to do. The Constitution gives Congress the explicit power to set the size of the Supreme Court and other features of its operation. And yet that one seems to have a lot of punch that other norm violations don't. So what's different about this? I mean, it's a perfectly constitutional move, but it's somehow seen as like, well, that you can do all this other stuff, but that's the one you can't touch.
That's interesting, and I think there's a couple. To my intro to American, I taught two articles alongside each other that have came out fairly recently. One, Julia Azari's article about how we should think in terms of democratic values, that not, norms can make it sound like you're just talking about, using a salad fork or something. That we're really, really getting at here is, the values needed to preserve democracy. And there's also a recent column written by Jamel Bowie in the New York Times where he talks about the election of 1800. And that really illustrates that even in very early years, when the Constitution had just been ratified, the democracy can't work if everybody is pursuing maximal power all the time. The legal scholar Mark Tushnet has a phrase he uses called constitutional hardball to refer to things that are formally constitutional but not normative. So Jamel's example with the election of 1800 is that it would have been completely legal for the Federalist House of Representatives to just make John Adams the president again, even though he'd clearly lost the election. Once the election went into the House of Representatives because of another defect of the constitutional model, the Federalists still controlled the House, although they lost the election. They could have just made Adams the president, but they didn't even consider that. And then ultimately, they were fortunately convinced to make Jefferson the president rather than Aaron Burr. But that's really, that essentially the overuse of constitutional hardball could have strangled American democracy in its crib. And, that's kind of the same thing that's, that's happening is that, there's lots of things that you can do that if you do them, then it's a problem. my position on sort of packing or expanding the court is that I don't believe that it's any less normative than what McConnell did starting in 2015. Essentially the Republican argument is that the Senate using its Article 2 powers to just serially refuse to consider any nominees of a president is somehow fundamentally different than Congress using its Article 3 powers to expand the size of the courts. I don't see any normative or legal, again, if anything, expanding the court has more historical precedent than what McConnell did. So, I don't find that argument very credible myself, but the question is whether, other people will find that or whether it will persuade the relevant lawmakers. And I guess I would say that the other and I think that there are real costs that would come from expanding the court. Once the 9-justice equilibrium goes away, almost certainly the next unified Republican government will, try to do something similar. It could be a real issue. But having said that, I think that a court representing a faction that will, as of next Tuesday, have lost the popular vote in 7 of the last 8 national elections, preventing the opposition party from governing is also pretty problematic. And it strikes me that, one can make a pretty good argument that, if the party that takes over the government should have their vision represented in the federal courts, is the least bad alternative to a situation in which, a faction representing a minority of the American public just can stop the other party from governing. So I think that that's what makes this so difficult. But I actually don't feel that the case that court packing is somehow uniquely non-normative is very convincing to me, although a lot of people would obviously disagree with that.
Great, thanks for that answer.
Do you mind actually if I
oh yeah, of course.
on that? Yeah, and I guess, I'm turning the question sort of back to Professor Lemieux, but I'm wondering what you think that would mean for judicial legitimacy if the Democrats were to pursue that option. So if they increase the number of justices, and particularly during this, very politically polarized moment, it would, effectively dilute the power of the conservative bloc and, allow them to promote their policies without consistently getting blocked by the courts. And it would sort of reinforce those short-term goals. But it would also, I would think, reinforce this sort of sense that partisanship is the main determinant of the court's decision, right? That the Democratic majorities are essentially enlisting the court as a partisan actor, and any remaining semblance of independence and impartiality would be seriously undermined. As you mentioned, it would also invite a Republican response when the tide turns. So I'm wondering, maybe if you could, speak to that a little more in the issues of judicial independence and judicial legitimacy.
Yeah, and I think those are all very serious questions, and I think all very serious questions for a Democratic Senate to continue to consider should one happen in 2021. And I think there's no question that that expanding the courts would probably undermine their legitimacy. But the other way of looking at it is that who's ultimately responsible for that. And I guess the key to me is there's a big difference between a court that kind of produces more conservative than liberal outcomes, but fundamentally lets majorities govern, and one that doesn't. And I guess I feel ultimately that the Roosevelt administration would have been justified in expanding the size of the court had the court continued to strike down New Deal measures. So that in a sense, I think that there's a serious potential for sort of undermining the courts, but I also feel that it would be problematic to just go from that and say that therefore just the courts could do literally anything and not be held accountable. Like, I guess the way I would look at it is that checks and balances are always reciprocal. The courts don't just sort of stand alone as, sort of the one branch of government that can check but cannot be checked. And I don't think that's the structure of the Constitution either. So, in some sense, and I think one upshot of that is that I very strongly doubt that there's going to be the support for expanding, especially the Supreme Court, when Democrats take over, if they do, in January 2021. I think that if there is a judicial reform measure, it's most likely to be in response to the Supreme Court striking down the Affordable Care Act, or striking down a robust Voting Rights Act or something along those lines. But I think that those are also very important norm violations by the Supreme Court. Frankly, I think the Roberts Court engaged in a very serious norm violation when it has essentially rendered the most important civil rights act since Reconstruction, the Voting Rights Act, a dead letter based on legal reasoning that is extraordinarily unpersuasive to anybody who doesn't already accept that position a priori. So I think that there's a real issue here in that I essentially agree with every premise of your question, but there's also the problem that simply the Supreme Court that just refuses to allow a legitimately elected government to govern is also engaged in serious norm violations. So I wish I had a better answer for sort of how to address that. And again, I think one real issue we have is that the Constitution makes more radical measures easier than perhaps more modest or consensual measures. And I don't even know if it would be possible for us to make an agreement about a more moderate course. But the difficulty of amending the Constitution, I think, makes that more difficult. So I don't know if that's a satisfying answer, but I think your question underscores that it's a very, very difficult problem and not an easy one to resolve.
Yeah, great dialogue there from both of you. Appreciate that. So I'm going to bring in another question. This is for Professor Thorpe. So there's this concept in political science known as to be a disjunctive president. And we have a question asking whether if Donald Trump loses next Tuesday, would that then make him a disjunctive president? So I guess to address it, you want to first explain what that term means and how this might well play out in the history books.
Yeah, sure. I think that Professor Lemieux, if he wants to, can also chime in on this. He's an expert in this area of presidential politics as well. So a disjunctive president is a term that Stephen Skowronek, political scientist, came up with that basically characterizes presidents based on their positions in presidential typology. So there's a reconstructive president that sort of redefines a political era for their coalition, which in our sort of modern parlance means their political party. And the disjunctive president signals the very end of that coalition. So sort of the collapse of that party's political era and the beginning of something new that a new reconstructive president of the opposing party will go on and create. So if Trump loses, then I guess by Skowronek's own, by the rules of his own typology, it would suggest that he is a disjunctive president and he's the last in Reagan's era. So he was governing within within basically the framework that was set up in Reagan's administration. And that, the coalitions that were held together within that framework have, more or less, sort of, they're too fractured and they're too weak to continue to govern effectively. And it would suggest that, the Democrats are going to be empowered and, will create sort of a new model or a new framework for governance. But I know that there's also been a lot of discussion and a lot of critical discussion of Skowronek's typology and whether it's even really relevant in a sort of very hyper partisan era. So whether it even really applies to the situation that we're in now. I don't know if you want to add anything on to that, Professor Lemieux.
Yeah, because I'm actually working. I mentioned my friend Julie Azari, and we actually have a paper that we sort of have to wait until this election comes out to finish. But if you Google my name and long disjunction, Tom Edsall wrote an article in the New York Times that looks not only at our paper but at the kind of debate within political science about this. And essentially, right after the election, she wrote an article kind of making a really strong case that Trump would be a disjunctive president. And I wrote an article basically saying that, and I say this as somebody who greatly admires Skowronek's work, and I think that it has an enormous amount of purchase throughout history. But I think that we're in a period where it doesn't really apply very well, simply because the model basically assumes that you have kind of one dominant governing regime. So essentially, presidents are either working with it or working against it, or at the kind of end of the line. And I guess my theory is that we're in a situation right now where there's just basically no one governing regime. You have Democrats essentially trying to carry forward the tradition of the New Deal and the Great Society, and you have Republicans, and really Trump governed as a more orthodox Reaganite than Reagan himself, which I think a lot of people didn't predict, but I think was predictable. So at any rate, Julie and I kind of talked about it and realized that we didn't so much disagree as we were kind of talking about different things. And so our theory is that we're right now in what we call a long disjunction. That the difficulty is that pretty consistently, a not huge majority, but a majority of voters have preferred Democrats. But the Republicans essentially have a representative advantage, a large one in the Senate, and a less large but still significant one in the House and in the Electoral College. And with that, traditionally, parties have realigned because if parties aren't competitive electorally, they more or less have to moderate and change and then try to do something else. The difficulty that we have now is that although Republicans are a minority party, they can remain very competitive in presidential elections. We could be looking at Trump right now is losing in the polls by upwards of 10 points, and Republicans still have a chance of retaining the Senate. So essentially, it's not a very happy outlook, but essentially, I think that we're in a situation where there's just kind of a more general disjunction in American politics, which is that you have, two parties with very, very different agendas and no real way of resolving the conflict because the less popular party can still be very competitive at both the national and the state level. But again, there are definitely political scientists who have a more optimistic view and believe that there is the potential for Biden to be kind of a reconstructive presidency that will realign and kind of cause the Republican Party to tack back towards the center. And it has happened before. There certainly have been periods of polarization in American history that have not endured. So it's impossible to predict the future, but that's how I would see it anyway, is that I don't think that Trump could be a traditional disjunctive president because that implies that we're about to go through a period of kind of a dominant new Democratic regime, and I don't really see that happening. So kind of as Professor Thorpe kind of implies, I'm not sure that that model quite fits our current historical moment.
Well, that might be the note for us to end on, just because we've run to the end of our time.
Sorry, I wish I had a better story.
Yeah, I'm not sure what the right way. What's the correct tone to strike at this point? But everyone has their own tones, I suppose. And so I want to thank you all for coming tonight, as well as to our two panelists, Professor Lemieux and Professor Thorpe, for leading us tonight. So this will conclude our three-part political science election series. But as Professor Lemieux noted, the Wiser talk on race in the 2020 election is actually a post-election event. It's on Friday the 6th at 11 to 12 o'clock. So many of you are on, if you're on an email list where you got alerted to this talk, you probably got alerted to the other one. But if not, you could just Google the website WISIR. And I think it's also linked on the political science department at UW's homepage as well. All right, so thank you all, and good night.